So next we have joining us Annette Hines and Mark Worthington, husband and wife, who are also incredible Mito parents. Their daughter Elizabeth was one of our Mito warriors that we lost, but Annette and Mark have continued to support our community and to be here and to provide education and support to other families that have gone through what they have gone through to make their journey a bit easier. So we are not going to have a Q&A session with this presentation because Mark and Annette have so much great information, but they will be available at 6 o'clock during the roundtable discussions to answer all of your questions live. So please keep track of your questions, write them down, and come back at 6 o'clock in the lounge to join Annette and Mark to ask your questions. So Annette and Mark, take it away.
At noon tomorrow too. So two times.
Ask if they see the slides.
Can everybody see the slides okay?
Yes,
we can't see the chat. So I just want to make sure. This is a little different format from last year, and it's a little unnerving not being able to see everything. So, okay, so we are going to get started with our slides. Our slides today are in two pieces. We're going to talk about some recent developments, what's moving and shaking. This is an unbelievable year. So much has changed and so much is going on. And some of what is going on is purely speculative and some is really a done deal. But the rest, we are going to do some basics too of planning. So that's what we're going to be talking about today. So some recent policy changes. The Families First Act has been most of what we've been talking about this year. 6.2% increase in what we call the FMAP, the federal match for Medicaid, through the public health emergency. That emerged last year and through early part of this year. And that was also rolled out in the American Rescue Plan. So you may have been hearing a lot about this for the last 12 months, where states were eligible for a 10% federal match increase for home and community-based services. Mostly this was to supplement and not supplant state spending, and most states have taken that up. I don't know what's been happening in your state, but maybe you want to, kind of think back to what's happened. The Medicaid Money Follows the Person program, which is a waiver program, was extended to 2023. Now, many states have taken up this grant, which allows states to pay for transition services out of institutions such as nursing homes. So that's another great program that was extended, and many states again have taken this grant. So lastly, direct service support professionals under Medicaid can attend during hospitalization and skilled nursing facility visits. So that's unusual because that's an opportunity for two Medicaid providers to be billing at the same time. So now let's talk about the American Jobs and Families Plan. So earlier this year, you may have been hearing about this as well, President Biden proposed two massive tax and spend plans, the American Jobs Plan and the American Families Plan, which included $400 billion, yes, you heard me right, for Medicaid home and community-based services, which also included a paid family leave program and also extended child tax credits. So where are we right now? And we are just about finished with all of the negotiations that have been going on, and we're about to take a summer hiatus. So we're on two tracks.
With all of the negotiations.
I'm hearing a little echo, but we're on two tracks, track one and track two. Track one has physical infrastructure, likely a bipartisan deal, and track two, which has everything else, a Democratic only process called reconciliation, which allows them to bypass the filibuster. So I have been learning a lot about this. It is a brain buster of a process. I could go more into that, but it would take me hours to explain how this is happening. So if you're not familiar with democratic process, it is really just mind-blowing. Anyway, The Democrats appear to be close to agreeing to a $3.5 trillion package on track 2, but we're still waiting for all the details. We are likely to get a vote in September and hopeful by the end of the year to have some sort of a plan. However, it could all blow up still. In the Senate, the Better Care, Better Jobs Act is proposing $400 billion in home and community-based services funding, and 40 senators have also co-sponsored and counting. So this has 2 goals: increased direct support professionals' wages and increased access or reduced wait lists for home and community-based services. So this is going to be accomplished primarily through massive funding opportunities to the states. There's a lot of incentives for the states to pick up these programs, okay? They're going to be rolling this out and hoping that all of you, the American public, will put pressure on your state legislators to accept what they're offering and what they're dangling as carrots. So this is where you get involved. So to access these funds, states must address access barriers, require coverage of personal care services, sounds good, right? Provide presumptive eligibility for home and community-based services, and provide supports to family caregivers, including respite care, and may also include providing such services as caregiver assessments, peer supports, or paid family caregiving. All sounds great, right? So to qualify for funds, states must provide the opportunity for you all to be part of the process. This funding will likely end after 10 years, and here is where you can get involved. So you must urge Congress to pass Senate 2210, and if it passes, you have to get involved at your state level to shape your own state plan. So here's what's happening in my state. ARC Mass has created a sign-on letter. This was happening in our state delegation just this past Tuesday. And I just wanted to show you basically the language that was going around all through all our various organizations. So now I'm going to move on to SSI. So hooray, you know, we actually might be able to pass some expansion this year. We have been waiting decades for this to happen. But SSI advocacy is at an all-time high. And our advocates are pushing to expand SSI, even though it wasn't exactly included in Biden's American Families Plan. But advocates are rallying around the sentiment right now, and the SSI Restoration Act is a major focal point also for policy right now. So what they're looking at is to increase the asset limit, which starts right now at $2,000 and hasn't been changed since the 1970s, right, Mark? Mm-hmm. And they want to increase that asset limit to $10,000. They want to end in-kind support and maintenance, which I don't have a ton of time to go into what that is, but many of you probably already understand that that is a penalty, basically, for being provided room and board, essentially. And they want to repeal the marriage penalty. So look, it's a long shot because just this past week, the auditors came out with what the numbers were going to be, what it's actually going to cost to do some of this. And it's an outrageous number. But some of the other items have more potential to pass. So the Social Security Administration plans to propose that the definition of ISM no longer consider food as a source. And that is expected to pass in November because they don't need to actually go through Congress in order to change that definition. They can do it themselves. So we think that that's going to happen. There will be an opportunity to submit comments on this important piece. Now, regarding housing, another big change. So the HUD final rule from the Housing Opportunity Through Modernization Act of 2016 is finally coming out. It's expected next month. And one big question that still remains to be answered is whether distributions from special needs trusts will count as income. So we think we know the answer to that based on some back and forth commentary that's been happening, and we think it's going to be very positive. But we're still waiting for that final rule. Okay, regarding representative payee accounting, SSA proposed rule reducing the burden on families is expected in spring of next year. So we thought we already understood what was happening based on the Strengthening Protections for Social Security Beneficiaries Act that came out in 2018. And we thought we were scratching our heads like, hey, didn't this already get implemented? And it has kind of sort of been implemented, but not uniformly. So as of next spring, for sure, we are going to have certain family members, especially parents, who are now not going to need to fill out these rep payee reports. Okay, if you haven't been living under a rock, I think you've heard about the Britney Spears movement. It has basically penetrated all aspects of media, from Teen Vogue to the New York Times. Free Britney has been, in addition to some other media like I Care a Lot as a movie and other documentaries, has been impacting how people, the general public, views guardianship and conservatorship in our country. Not a bad thing, frankly. Guardianship has needed a spotlight shown on it for a long time. So NALA, the National Academy of Elder Law Attorneys, and many other groups have been meeting for a long time, long before this Free Britney movement, and the I Care a Lot movie came out, to discuss reforming adult guardianship. And as I close out here, I just want to talk to you about 5 areas where the National Guardianship Network had some final recommendations to reform the adult guardianship system. And this is what's coming. Meaningful due process. So in the Britney Spears case, one of the main issues that came up, and it's a little complicated to talk about, and I'll be happy to answer questions in our roundtable discussions about this. But one of the main problems was that Britney wanted to hire her own attorney, and she was denied that right. She was given a court-appointed attorney, and gag me, that court-appointed attorney was paid somewhere around $900,000 one year out of her money to protect her rights and to advance her interests. Yet that person was not actually listening to what she wanted. I really must insist that would never happen here in Massachusetts. Court-appointed counsel is a right here, but the fact is, meaningful due process is not uniform across the states. And that is one thing that the national network is looking at trying to implement uniformly. The second thing is supported decision-making in a way to minimize guardianship or limit guardianship where appropriate. And that's just another way of having individuals with disabilities who need some support in making their decisions known can be supported without a guardianship when possible. That's a whole nother ball of wax, but there are, I think, 15 states now that have supported decision-making statutes, and another almost dozen states that are in the process of trying to implement new statutes around supported decision-making. The third is uniformity and a uniform act around guardianship. We have 52 different state guardianship laws, and they really are all different. And having a guardianship in Massachusetts does not mean that when you move to California, you can easily transfer that guardianship. They do not move from state to state very easily. Think about when you get married in Colorado and you move to New Jersey, you don't have to worry about your marriage not moving with you very easily, right? Or adopting a child or anything like that. But a guardianship really does have that flaw. Fourth, they talk about monitoring and oversight of a guardianship. And this, again, was very flawed in the Britney Spears case. And data collection of what's happening to people once they become subject of a guardianship or conservatorship. And lastly, addressing conflicts within a guardianship case. What happens with all the stakeholders within that guardianship case and how we can improve court process and court programs to make anytime somebody is subject to a guardianship, if a guardianship is found to be necessary, to make it as painless as possible for the parties involved. So these are aspirational, of course, but these had been hard fought and discussed and come to as aspirations back in May of 2021 before Britney Spears case exploded. So.
All right. If you've heard of the Secure Act, real briefly, I've got a few slides later on, but what's new and shaking is the IRS will have proposed guidance they expect on that. It's not regulations, it's not proposed regulations, it's guidance on the Secure Act. The Secure Act is the provision in the law that was enacted in late 2019 that said no more lifetime minimum required distributions if you leave your IRAs to your kids. They have to take everything out after you die within 10 years of your death. Significant exception for that is retirement plans left to a special needs trust if it's drafted with certain provisions in it. But the act left a lot of open questions. They expected to get guidance out to us by June of 2020. NAILA, my committee there, the tax committee, submitted questions that we wanted answered in March of 2020, and then but then the pandemic hit, and we've never received anything since. But it was NAILA, by the way. I'm going to give a shout out to them. It was NAILA and our tax committee that got that exclusion for supplemental needs trust. It was not in the original bill. So you're welcome. All right. Ready?
So as we're moving on to our tax proposals, also, I just wanted to mention that we have a resources page that is going to be posted that will talk to you about a lot of what I mentioned here so that you don't have to feel like you had to scramble to write all this down. There's information there about how to get involved at your state and federal level, how to even find out who your legislators are, how to get involved and find out, what's going on with Social Security, the national network for all of those guardianship aspirational standards that I mentioned, and so forth. So I've got hyperlinks for everything there for you.
All right, so this is a hodgepodge on this slide. This is a hodgepodge of all of the nutty tax proposals that are out there right now from the president or certain senators or certain representatives in the House of Representatives. None of what's here is law. But the thing that would affect most people, despite the president's vow to not affect anybody earning less than $400,000 in a year. If you look at that third butterfly there, step up in basis at death, some of you may know that if you die owning most kinds of assets like, a house or stocks and things like that, things not in a retirement plan, that whatever you paid for it that income tax basis for capital gains purposes gets, quote, stepped up to its value at date of death, and your heirs can sell that property with little or no capital gain tax. Various proposals want to eliminate that, or cap the amount that you can cap the amount of gain that can get forgiven at death, or make death a realization event, so that if you die and you pass, the family farm on down to the kids, suddenly they realize capital gain, whether they have the cash to pay for it or not. So I'm not going to go through all this. If anybody wants to talk about any of these bullets during the roundtable, we can.
Yes, if you're a tax geek like us and you want to come and hang out and talk tax with us, we would love that.
Right. So let's get to the basics here, though. Whether there's tax or not, let's take a look. So when people ask what's estate planning, right, most people think about it's wills or it's estate tax planning. So nah, NAW, 3 exclamation points. It's 2 things. It's ensuring that the right people are in charge of you and your family at the right time, no matter who gets sick, who gets incapacitated, or who dies, in what order, and no matter when. It also means ensuring that your assets benefit you and those you love, not benefit their future creditors or their divorcing spouse or whatever, or the government. That's my way of saying government. And that can be taxes. It can also mean making sure that the assets are non-countable for public benefits purposes for some of our beloved kids who really need those benefits. So why plan? Because you want to accomplish those 2 things and not have icky things happen, like assets ending up with people you don't expect, et cetera, et cetera. Now I'm moving fast here because I don't have much time.
But also you plan because you don't want to end up in a guardianship.
Well, that too. So yeah, if you do planning the right way, it greatly reduces, never eliminates, but it greatly reduces the odds of you having a court-appointed guardian or conservator. So the most common estate planning documents that we have are these: wills and trusts, powers of attorney, healthcare proxies, HIPAA authorizations. And so let's start with, let's take a walk through time. You're fine right now, at least I hope you are. But at some point, maybe you're not so fine. The ice cream truck hits you, but it didn't kill you.
Why do we always say ice cream?
Because that's you. I just pick up on you.
All right.
So a revocable living trust can be an incapacity document to the extent that it's funded. But the classic ones, and I use that word advisedly, since these documents, the oldest of these documents, durable power of attorney, healthcare proxy, and HIPAA authorization, have only been around since the 1970s. And HIPAAs didn't come in until the early 2000s. So what these are power of attorney. It's a concurrent power with the principal. The principal is you. You sign a power of attorney. You give your spouse or a child or
your best friend
or somebody that you found living under a bridge.
Somebody
the power
to
the power to take all kinds of actions for you other than medical decisions. And if you don't like what they're doing, you can fire them and you can overrule them and so forth. The authority, we often see this misunderstanding. Somebody's died and somebody says, well, but I'm their power of attorney, so I can go do this, that, and the other thing. No, you can't, because the authority ended when the principal ended. So the most important thing to know is that powers of attorney, it's not one size fits all. It's not like saying, hey, my Bayer aspirin is the same as my Walgreens aspirin, et cetera, et cetera. They do have different powers listed in them and so forth. And we often find that they are missing key powers that we need for things like good tax planning in a crisis, or good public benefits planning and so forth. Healthcare proxies, that's what it's called in Massachusetts. Other states call them things like durable powers of attorney for healthcare, et cetera. I believe in every state that these are so-called springing powers, meaning that they're not good until a doctor says they are, until you become incapacitated.
So they get entered into your medical record at some point.
Yep. They're generally not effective just for day-to-day stuff. Ordinarily, we are not super advocates of, fill in the blank forms, but in terms of healthcare, probably 95% of the time, whatever you fill out in a hospital is going to be adequate to the case. Yeah. A really good healthcare proxy will increase that to like 99+%. One thing that we see often happens that we don't like is you get carted off to the hospital. You get there, you're still kind of functional, and they say, "Oh, like here," and they shove this this blank form in front of you in the ER and say, "Sign this," and it's a healthcare proxy, and what it does is it revokes the healthcare proxy that's a better one, and with the people you really want listed on it that you did with your beloved attorneys. So just be a little bit aware of that. It's good to have a copy in the glove compartment. It's good to have spread it around amongst all the people that you love and that are listed on it. And there's also services like, what's the one that you were, I can't remember the name.
There's all kinds of DocuBank.
Yeah, DocuBank, that's it. Mm-hmm. So DocuBank was one of the leaders. I think they're still the leader, where you can take your healthcare proxy and HIPAA authorization, and now things like powers of attorney and other documents, have them on electronic file there. You pay them a very small fee annually. Mm-hmm. You get a little bracelet or a chain or something to put in your wallet. Hospitals know to look for these things when you get carted into the ER and you're unconscious.
Right.
And they will look and they will say, this is their number at DocuBank. And within minutes, they have a copy of your healthcare proxy, et cetera, like that.
And you don't even need to do it with an attorney. You can do this on your own. You can fill them. You can do it online.
So just the healthcare proxy, please. Don't talk about powers of attorney.
I mean, if you have your documents already, you can work with the DocuBank service. I don't mean you can do the documents yourself online.
Well, that's the problem is you can do them online, but you won't know if you've got an issue. Okay, the HIPAA authorization came in 2003 when we got very detailed and actually quite well thought out regulations, HIPAA regulations, medical privacy regulations. The problem is that they are incredibly complicated, and for that reason, in some respects, kind of impractical. But
yet they seem so simple.
But the healthcare, the HIPAA authorization is a very important document to have. And basically, it's not authority for anyone to make medical decisions for you. But unlike a healthcare proxy, it's good immediately. And it authorizes doctors, hospitals, health insurance companies, and so forth to talk with those people that are listed in the HIPAA authorization and provide them information, provide them with medical records, et cetera, without the specter of financial fines and criminal penalties if they do that.
So one quick little practice note here. It can be very helpful in situations of divorce where you just have one spouse who kind of does everything and has really taken the lead with an adult child with a disability. You can share information, all kinds of information, through having one person who's the guardian fill out a HIPAA authorization for the other parent to be able to get medical information without that guardian having to be the gatekeeper. And then, you can actually keep the peace that way.
All right. So I think we're actually have a prayer here of getting through our slides. We're halfway through.
That's great.
All right. So other health-related documents, living wills, other advanced directives, DNRs, anatomical gift forms, MOLST forms, medical orders for life-sustaining treatment. These are
very state to state.
They're state to state specific. I see a great, in my view, overemphasis by clients on these documents and an underemphasis on the importance of the healthcare proxy. That is the most important document, followed by the HIPAA. These directives are fine, but I think that you should actually not have directives. I think that you should have guidance for your healthcare agent, except in the kind of a situation where, maybe it's a hospital situation, you're in dire shape, and maybe your healthcare agent signs a DNR for you. That is a directive for the medical providers. Anymore, Annie?
They bump up against a lot of state guardianship statutes, and you have to be very thoughtful about what a guardian has the authority to do when it comes to end of life decision making. It's really just heck in every state when a healthcare agent can do X, but a guardian can only do Y. So, it's really important to do advanced planning all day long.
All right, so what does a will do? Everybody thinks the will is so important. It's one of the least important documents that you can have in the world of estate planning. It specifies distributions, but only for things that go through your probate estate. Nominates your executor. Of course, only the judge can appoint the executor, but you can nominate all day long. And you can nominate guardians and conservators of minor and incapacitated children. So that raises the question of, okay, so what the heck is probate? Now, if we're doing planning where we would avoid probate, doing planning that we're going to pick up probate avoidance on the way by, fine. But we don't really consider it a super primary goal.
Yeah.
And there are some times where we actually want to deliberately engineer a probate for certain Medicaid reasons. So what matters is what I tell people all about life. There are no solutions. There are only pros and cons in getting the most of what you want and the least of what you don't. So that's what you try to do in anything, including estate planning. So the process is you petition to have the will allowed and the personal representative appointed, the executor. Then once you've done that, you inventory and marshal, that means gather together assets, give notice to creditors, heirs at law, beneficiaries. Heirs at law and beneficiaries are not the same necessarily if there's a will. Heirs at law are the people who would be entitled to inherit if I had no will. Pay income and estate taxes, if any, pay debts, make distributions, file an official account, and close. That's a lot of work, believe it or not.
And a long process.
But what assets do go through probate? It may be nothing. It may be everything. It's usually actually less than half of what you have. But what goes through probate is what assets that you hold purely as an individual that have nowhere to go when you die. It's like you keel over and what was in your hands drops to the floor and nobody's holding it. The job of the probate court is to get somebody to pick it up and own it. So what's easier to understand is non-probate assets.
Yeah, I think it's important just to remember that the probate process through court is primarily a process where two things happen. Assets are properly retitled to the new owner, and notice is given to creditors, which gives them an opportunity to step in and get paid their debt before those assets go off to their new owner.
Yep.
That's really what's happening here.
So what avoids probate? What are non-probate assets? Stuff that's got somewhere to go when you die without the courts bothering it. Jointly held assets where there's one or more surviving joint owners. Okay, not held as tenants in common, joint with right of survivorship, which we usually just abbreviate as joint. Assets with a death beneficiary designation. We often call these contract assets because they pass by that designation by the contract. You will often see this abbreviated as pay on death, POD, for things like bank accounts, if the bank account even allows that. Not all bank accounts do. TOD is transfer on death. That's for securities and brokerage accounts. Again, not all accounts offer that.
Right.
ITF is a weird one dating from the late 1900s called in trust for. You see that on some bank accounts. Most common.
Not so much anymore.
Not so much anymore, but you still see it a lot, and people think they have a trust account, and they don't. That's not a trust account just because it says in trust for. And then death beneficiary designations is the most common thing, and you see that on life insurance, IRAs, qualified retirement plans like 401ks and 403bs, annuities, et cetera, et cetera. Now, another thing that doesn't go through probate, some of you may have heard of life estates. Also, some states have beneficiary deeds or ladybird deeds, things like that, where you have not transferred any interest in the home at all, but there is a death beneficiary designation sitting in the registry of deeds. Not all states have that. Massachusetts, for example, does not. And then we have assets owned by trust. And the reason that even if you create a revocable trust, if you keel over and die, or ice cream truck did a really good job and clobbered you, then okay, you're dead, but the owner is the trust, and the trust didn't die. The trust just gets a new trustee if you keel over. So that's what avoids probate.
Now let's give an example of what that looks like. So I'm Italian, and you know, in my old neighborhood, all the old Italian families would, you know, would think that some of the planning that we talk about, oh my God, too complicated, right? So what they would do was they would take all their kids and they would open up a joint bank account with each one of them. And they would, you know, try to even it out. So they would make sure that there was like, you know, $10,000 with each of their kids. Let's say they had 6 kids. So each account would have, you know, John and Joe and Sally, you know. But then through the years, as they get older and they needed to grab money, you know, to live on, they would maybe not necessarily be taking out the money evenly from each account. So then when they died, maybe, you know, one account has $20,000 left in it, another account has $6,000 left in it, and so on and so on. So as you can imagine, their plan for how they wanted to equally leave money to their children was frustrated at the end. So using these joint bank accounts was not necessarily the best.
And you know, what they're doing is depending on, you know, the kids all working things out. And some families that works, and some families that doesn't. And it only takes one disagreeable child to create a problem. Also, parents oftentimes will overestimate the degree to which there will be family harmony once the parent is gone. Sometimes that's what brings out some of the disharmony amongst the kids. So
now we've seen people fighting over refrigerators and you know,
the snow globe from the trip that they all took when they were 10 years old. All right, but I'm sorry, we got to keep moving.
We digress.
No, you did. You digress. All right, so look, trust. What can we use them for? Some things are fairly straightforward. Some are awesomely sophisticated. Trusts are like the pinnacle creation of the common law, begun 750 years ago in Oxford, England. So avoid probate.
Mark gets very excited.
I do too. Yeah, I do. Yeah. So avoid probate. That's an easy one if they're fun, but they have to be funded. You can't just create the trust and then toss it in the corner. Manage assets during life and even decades after death.
Very easy to separate a percent, you know, 1/6 to each of the 6 children.
That's right.
And you don't have to worry about
if it all funnels into the Rev Trust, then it can splay out in even divisions and you don't have to worry about it. I do get some clients, particularly ones who are at the older end of the spectrum, like the far older end. This asset, this CD needs to go there and that CD needs to go there. And most of the time, the better approach is have everything funnel into one place where it all gets divided up the way you want it. Right. So asset protection, especially for the kids, it's far harder to do asset protection with your own assets to protect it that you still want to benefit from. That's another completely different thing that we could talk about. Protection of irresponsible or vulnerable beneficiaries from themselves. If they are spendthrifts, if they have substance abuse problems, if they just, they're not smart, you know, like they just don't have good judgment, or they're constantly vulnerable to the next woman or man in their life, etc. Estate tax reduction or elimination, planning for long-term care needs and public benefits, providing for charitable intentions, lots and lots more. Now, one of the biggest issues that we counsel people about and that we have a lot of creative solutions for is who's going to be the trustee, either while you're alive or, more to the point, once you're gone. It's especially a difficult issue where you have problem kids or disabled children, and especially where we are looking at the very real possibility of the trust going on for the lifetime of your children, even grandchildren, so that anybody you personally know is going to be long dead and won't be able to serve as trustee.
And that's a long discussion.
Right. So family members, friends, professional trustees, institutional professional trustees. You can have, under certain circumstances, you can have beneficiaries be their own trustee, the children or whatever. Issues about guardians also serving in the dual role of trustees. So we can't talk about any of the, this is like
long discussion.
This one slide is a several-day discussion. The most common trust is a revocable living trust, RLT. Can provide centralized asset management during life. It can be superior to a durable power of attorney for various reasons, mostly having to do with obstinate financial institutions. But unfortunately, there are some assets which you simply cannot transfer to it, and the dominant one being one of the most prevalent assets that people have today, which is retirement plans.
Most people that we plan for have a home and their retirement accounts as their primary source of wealth.
Yep. Can provide for succession of management. Very flexible. If you can dream it and it isn't impractical, which I will tell you if it is, we can almost certainly draft it. Can provide, after you die, lifetime asset protection for the tiny ones, divorce protection, public benefits protection, etc. It does not, a revocable trust does not provide asset protection for you, does not protect against the cost of long-term care, does not save estate taxes for a single individual, does not affect your income taxes.
So we got to stop for a second and explain a little bit about those things.
I will let you do that because I don't know what you're talking about.
I don't want to blaze by what those things mean. So many of our clients will come to us and they'll have the dual purpose of wanting to plan for their children, and we'll have that disabled individual child or a disabled family member that they're planning for, but then they'll also have concerns about their own long-term care planning and the costs of long-term care for themselves. A revocable living trust is not going to be able to protect your own assets for your own long-term care. And that's what we're pointing out here at bullet 2. So you have to do a different kind of planning for protecting your own assets for long-term care. Now, for the most part, there isn't a ton of protection. There isn't a lot that you can do for long-term care planning, despite what you hear on the radio and despite what some firms will be hawking, for you. And it depends state to state what you can do, because there are some states that are more generous with their long-term care benefits through Medicaid than others. But a lot of what you're saving for your retirement is to pay for the care that you need and the things that you need when you are older and when you are retired. So that's one thing that I wanted to say. And then as far as the creator's income taxes, that can be confused a lot with estate taxes. So the income tax issue is just that this RLT is essentially you. It hasn't changed the nature of the assets that you own.
Right. And so basically, whatever your Form 1040 for the IRS would have looked like without the RLTs is the same way it's going to look with it. No difference.
So that is a good thing in the sense that when you move your assets to ownership in the revocable living trust, you haven't really complicated your life that much.
But look, so let me just say two things, and we've got to get going on the rest of the slides. One is the whole business about, can you protect against costs of long-term care or anything else that you may be interested in. and you hear ads on radios and stuff like that, and it says, you can save all of your assets, et cetera, et cetera. Look, the devil's always in the details, okay? What matters is the nuances and the pros and the cons. Everything in life, including especially, I would say, in any kind of estate planning, there's pros and cons. Let's talk about them all. Let's weigh them. And is it worth doing this for you? Is it not? What are the risks? What are the potential rewards? Are there alternatives to what you're thinking of? That's the kind of counsel you really want, not somebody who says, oh, here, look at this. You can do this. Put all your home in this irrevocable trust and you're fine. So the other thing I wanted to say is that, we often get people coming into the office and say, well, I want a trust. If somebody says to me that they want a trust, that would be kind of like saying, I want a vehicle.
You're right.
And it's like a vehicle. So do you want a car,
a tractor,
an SUV, a space shuttle, a tricycle? I mean, those are all vehicles. And that's about the level of detail you told me when you say I want a trust. I can work all kinds of miraculous things with trusts. I'm sorry, I got to brag. I'm a virtuoso with these things, but you have to understand what it is you're trying to achieve, what the pros are, what the cons are, make an informed choice with a good counselor who knows what they're talking about. We got to move on.
So it's really about your goals.
Yeah. Okay. Guardians for children, very quickly. Traditionally, the only way to do that would be you could, in your will, so you had to be dead for that to work. You could you could nominate guardians for your minor children, and that's it. In certain states, there's about 18 uniform probate code states, and like Massachusetts, there may be a few other states where you can do this too. But you can appoint guardians not just nominate guardians for minor children to take effect, not just on your death, but on your incapacity, and also nominate guardians for incapacitated adult children.
So exciting.
Well. It's really powerful.
Also another way to keep the guardianship beasts from, rearing its ugly head there. So.
All right, now,
okay,
the subject that a lot of people are obviously very interested in, which is special needs trusts. Sometimes we call them SNITs. I have to tell you, the first time I ever,
I know,
yeah,
what a
SNT,
word.
SNITs, and I thought in my head I kept calling it snots. But anyway, sorry about that. So you set up your own rules within the trust. There aren't very many rules that are set in stone by the law in terms of the trust. Now, public benefits is another matter. It holds and disperses assets for a beneficiary. One thing a lot of people don't know, and maybe the studio audience knows because they've been in this world a while, but most people don't get that there are really two kinds of special needs trusts, and what distinguishes them is where the money come from. If it's the disabled person's own money, we call it a, quote, first-party trust, meaning they funded it with their own money and they are usually the current beneficiary of the trust. A third-party trust is where somebody else funded it and that person that funded it's not a beneficiary of the trust. Typically what we're talking about there is the parent has died, leaves money in this third-party SNT for the disabled kiddo. Mm-hmm. And so,
but it can be grandma or a favorite aunt.
Right. But that's the typical one. Yeah, I mean, it could be Uncle Fred too.
But the two can never meet because if you put disabled person's own money into a third-party trust, you have tainted it.
You've destroyed it, and it is now a countable asset, even if it's drafted properly. So you can't put the disabled beneficiary's money into the third-party SNT without destroying it. Okay, so why important? Obviously, public benefits that have an asset test, like SSI, like some forms of Medicaid, like certainly institutional Medicaid.
Okay, so go back to the beginning of this conversation today. We were talking about a waiver program called Money Follows the Person. That MFP program, which brings people out of institutions, for example, has a $2,000 asset limit. So that's why trusts, special needs trusts, can be so important.
It also protects assets, and any trust can do this, doesn't have to be a special needs trust. But protects assets for vulnerable beneficiaries from themselves and from others. So
some of them can provide creditor protection, divorce protection, etc. Not self-settled trusts, unfortunately, but the third-party trusts can do that.
some self-settled trusts under the law of some states can, but in most states they can't. So what makes a special needs trust a special needs trust?
Those are my daughters, by the way. I love that picture.
So the one that looks really happy, that's Elizabeth. And you know, I guess from an objective point of view, maybe she had less reason to be happy than Caroline, because she's the one that had mito, pretty severe mito. Caroline is the one sneering there, and that expression has been frozen in stone. It still remains today when at age 20. All right, so we have to move on. So the Social Security has said that in order to have a first-party SNT, which you'll see, we call that a D4A trust, that the person actually has to be disabled. That seems a silly requirement to me, but we'll move on. Supplement but not supplant language. It doesn't mean that you can never ever distribute. If it's drafted correctly, it is guidance and not mandatory on the trustee, so it should be flexible. It's actually, by the way, not an absolute requirement,
right?
At least under federal law. I'm going to quickly tell you that for Medicaid purposes, not SSI, the 50 states will often impose requirements that are not part of federal law. And when they do so, they are violating the law. They get away with it for decades. Minnesota had one of the worst violations I've ever seen. I've been infuriated about it for over a decade, and they just got smacked down in court for it. So good on them. All right. The key to a properly drafted special needs trust is that it have a wholly discretionary standard for the trustee to make distributions. You don't see support language in there. You don't see things like health, education, maintenance, and support, that expression coming from the estate tax code, and it is pervasive all over the place in trusts.
Right.
There should never be any way that the beneficiary can demand, either on their own or by going to court, no way that they can force a distribution, compel a distribution out of the trust. Spendthrift clause, Social Security expects to see it. I will tell you, even though it should have a spendthrift clause, it is
not required.
It is not. I'm a trust guy. I know it's not required for this to work, but it should be in there anyway.
But just so that you understand, there are certain things that are on SSA's checklist. Attorneys are not reviewing these trusts. And if you make your trust look like every other trust that they are expecting to see, then it'll sail through, right, and you'll have less problems.
You do what you really have to do, which does not have any standards like health, education, maintenance, and support. You have complete trustee discretion,
right?
But you also have the unnecessary things. You have the spendthrift clause. You have the supplement but not supplant language and all that.
But it doesn't hurt anything. Your beneficiary is going to be fine.
Yep.
When you say sole and absolute discretion for distributions, it's actually really great.
Annette, I want you to talk to this slide, okay?
So many people come in to talk to us and they worry about whether they're doing the right thing by putting a special needs trust in place. And, you know, we talk about some common concerns that they have. And they wonder if their kiddo is not on public benefits, you know, now do they need a trust? And they wonder about the stigma of being on a trust, having a trust named a special needs trust, and then also about the expense and how, you know, difficult a trust can be. So very quickly, we never know when somebody may need to access public benefits, and special needs trusts are just awesome sauce. There's almost no reason not to do them because a third-party trust that a parent's going to use or a grandparent has all those other nifty things like asset protection and divorce protection. And in addition, if a person is not on public benefits, it can be used as a general support trust. So why the heck not?
Right. Even though it doesn't have support language in it, it can be used that way.
Right.
But I really emphasize to
the
people
trustee has discretion.
look, I could get into the history and it's terribly fascinating, but I won't. Let me just tell you, they're called special needs trusts for historical reasons. All right. But a properly drafted special needs trust is not restricted to only making distributions for certain things for the beneficiary, like only special, only this, not, no, it can pay for anything.
And we're running out of time.
So we're really out of time. So what I'm wondering is, you know, in our roundtable, you know, we can probably quickly just hit a few more slides.
We can talk about
and
those
finish
things.
this up if you want to. We could. So we have 2 roundtables coming up, one at 6, and then tomorrow, what was it, at noon?
Yeah,
or something like that.
And I think that essentially, if I look here, the only other thing that is super important.
Well, look. Well, why don't we end here? We'll pick it up next time. And we'll also have roundtable stuff at the first roundtable too. We're not just going to blather about additional slides. We good?
Yeah, I think so.
Thank you, guys. That was a lot of information to digest, but all really important information, right? To make sure that we are prepared for emergencies and that our families and the kids are taken care of long term. So this is all there. It's difficult discussions to have, but it's really important and critical for every family to be having conversations about estate planning and all of these benefits that are impacting our lives on a day-to-day basis. So as Annette and Mark said, they will be available in the lounge at 6 o'clock for all of your questions, and then back again on Saturday at noon in the lounge again for more discussion. So thank you both so much. I appreciate all that you do for our community. You are truly rock stars. We thank you.
Thank you.
Appreciate it.